Mr. Seeger, just Mr. Patno.
It is, Your Honor.
All right, we'll go on the record in People versus Nicholas Patno, case number 244928. If I could have counsel put your appearances on, please.
Seeger appearing with an idea, Mr. Patno.
Go on the record in People versus. Okay, Mr. Seeger, how did we want to proceed on this file today?
Your Honor, it's my understanding that people have offered Mr. Patno an opportunity to plead to count 1, count 3, and count 5. Additionally, Your Honor, this matter will be treated under HIDA, and then we would stipulate to the amount of restitution, which would be $2,000. Under the DNR code, based on antlers, there's different fines that are associated with it. However, we would stipulate and agree that it's 2 does as opposed to bucks, which at which point, Your Honor, the maximum fine would be $2,000.
Okay,
The restitution, I should say.
Okay.
That's a fair statement, Your Honor. I would also add that part of the agreement is that the defendant is not to hunt legally or illegally while on a HIDA status.
That is also true.
Okay, and just I might have missed it at the beginning there. Counts 1, 3, and 5. All the other counts be dismissed.
Correct.
All right, Mr. Patno, have you had a chance to talk to Mr. Seeger about this plea agreement today?
Yes, Your Honor.
And is that how you wanted to proceed?
Yes, Your Honor.
Raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth to help you God?
Yes, Your Honor.
You can lower your hand. Mr. Patno, are you currently on any kind of probation or parole?
Yes, Your Honor.
Okay, which one are you on?
Oh, no, Your Honor.
Yeah, I think it was referencing bond.
Yes.
Okay, all right. You understand that by pleading guilty to count 1, which is killing or torturing of an animal 3rd degree, that carries with it a maximum possible penalty of up to 4 years and or a $5,000 fine.
Yes, Your Honor.
And count 3, by taking a deer out of season, that's a 90-day misdemeanor and or a $500 fine. Do you understand that?
Yes, Your Honor.
And count 5, failing to tag a deer properly, that's also a misdemeanor of 90 days and or up to a $500 fine. Do you understand that?
Yes, Your Honor.
With all of those maximum possible penalties in mind, what is your plea to each of those charges today?
Guilty, Your Honor.
Okay, so you've got some certain rights at this point. I'm going to go through those with you. You have the right to have a trial. You have the right to be tried by a jury. You have the right to be presumed innocent until proven guilty. You have the right to have the prosecutor prove beyond reasonable doubt that you are guilty. You have the right to have any witnesses against you appear at trial and to question those witnesses. You have the right to have the court order any witnesses on your behalf appear at trial. You have the right to remain silent during a trial and to not have that silence used against you, and the right to testify at a trial yourself if you want it. You understand all those rights.
Yes, Your Honor.
You understand that you're giving up and waiving all of those rights by pleading guilty.
Yes, Your Honor.
Also, you don't have an automatic right to appeal the plea that you're making here today. If you wanted to try to do that, you would have to ask the Court of Appeals to hear your case. They could say no, and then that would be the end of your appeal. Do you understand that?
Yes, Your Honor.
Has anyone threatened you with anything to get you to plead guilty?
No, Your Honor.
Has anyone promised you anything other than what we've said here in court today?
No, Your Honor.
Is it your own free choice to enter this plea?
Yes, Your Honor.
Are you pleading guilty because you are guilty?
Yes, Your Honor.
Okay, Mr. Seeger, I'm going to ask you a question your client, just I'm not sure
Sure.
based on the charges what the factual basis might be here.
Mr. Patno, on or about 10/1 of 2022 through 11/2 of 2022, were you in Kalkaska County?
Yes, Your Honor.
And at that time, did you kill a porcupine?
Yes, I did.
And did you have any lawful reason to do that?
I thought they were a nuisance animal.
All right, but like you didn't do it in self-defense?
No.
All right. And then did you kill a deer during that time period?
Yes.
And was that in Kalkaska County?
Yes.
And was it out of season when you killed the deer?
I believe so.
And you didn't properly tag that deer at the time?
No.
Thank you. Mr. Ziegler?
I'm satisfied, Your Honor.
Mr. Ziegler, are the people aware of any threats, promises, or inducements other than what's been placed on the record?
No, Your Honor.
Mr. Seeger, are you?
No, sir.
And Mr. Ziegler, are the people satisfied that the court has complied with statute and court rule in the taking of this plea?
Yes, Your Honor.
Mr. Seeger.
Yes, sir.
Mr. Patno, the court finds that your plea is knowing, voluntary, and accurate. The court is satisfied there is a factual basis to support a finding that you are guilty of each of these counts. The court will accept your guilty plea as to all three. We'll set this matter for a sentencing hearing. We're going to meet briefly with Mr. Barrett, just to your right there before you leave court today. And before that sentencing date, just make sure that you stay in touch with Mr. Seeger so that you're ready to go forward, okay?
Yes, Your Honor.
Thank you.
Thank you.
Your Honor, Mr. Grow is not here, but Ms. Ash is here.
Okay. Mr. Ziegler, do we have any victims that are going to want to address the court on the Ash case?
I don't believe so, Your Honor.
People versus Ash, case number 244888. And record should reflect, you can go right to the podium. And the record should reflect Ms. Ash is present here in the courtroom today. If I could have counsel put your appearances on this time.
Brian Ziegler, on behalf of the people, Your Honor.
Thomas Stewart, Ash.
This is the date and time set for sentencing in this case. Ms. Ash, have you had a chance to review the pre-sentence report and talk to Mr. Seeger about that?
Yes, Your Honor.
Okay. Mr. Seeger, are there any additions, deletions, or corrections?
No, Your Honor.
Are there any challenges to the scoring?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
And you indicated that you do not believe there are any victims that are going to want to address the court today.
No, Your Honor, I haven't heard that they would like to, and I believe that's also what they indicated in the victim impact statement for BSI.
Okay, thank you. Anything then on behalf of the people for allocution today?
Your Honor, this is attempted at costing a minor for immoral purposes. The guidelines are on the lower end at either 0 or 3. The recommendation in this case is for probation. I think that given the nature of the offense, given the defendant's age, given her lack of any criminal history, given the fact that no minors were actually harmed as a result of her conduct, I have to agree that that's an appropriate recommendation. I'm sure the court has read through the PSI. The messages are clearly concerning. They were directed at minors. They were for a sexual purpose. There's no way of knowing how many other minors she may have messaged or how long this course of conduct may have continued. But the people at least feel comfortable that this individual will be on the Sex Offenders Registration Act for a period of time, and that is going to be a significant punishment for her conduct. I don't think she is likely to continue doing that behavior. So I think the recommendations contained in the PSI are appropriate. I would ask the court to adopt it.
Thank you. Mr. Seeger?
And likewise, Your Honor, I would ask the court to adopt the recommendation. And truly, and I do agree with Mr. Ziegler, this is an unfortunate situation. And probably in many ways represents somewhat of a dangerous situation, and whether it didn't elevate itself to something that could have been much greater and much worse. Be that as it may, Your Honor, and speaking with Ms. Ash, can someone understand what she's experiencing? Unfortunately, she was not thinking clearly, not making good decisions. Thankfully, it did not escalate to a situation where it could have been something much greater. But to her credit, she does not have any prior criminal history. She's generally complied with the objects of the bond. And I agree with Mr. Ziegler, in as much as the legislature may not deem it to be punishment, being on the sex offender registration is a punishment. And it's something that she's going to have to be monitored for an extended period of time. I don't think you'll have similar like conduct coming from her. I agree with Mr. Barrett that maybe some kind of course related to her actions may be helpful to her. But at this time, I would ask the court to adopt the recommendation, holding the jail time in advance. Who knows that she has no prior criminal history, and she's not likely to reoffend. She is very remorseful for what has happened. She's been in constant communication with me, expressing her remorse. How can I make this right kind of situation? So I think that she has learned from this. I think that going forward, she's not going to have a similar problem And I'm hopeful that she's getting the opportunity to be placed on probation, which is successful.
Thank you. Ms. Ash, was there anything that you wanted to say today?
I'm just very sorry for what I did. And I don't know why I did it other than just lonely and making the wrong choices.
Okay, I did read through the report, so I'm familiar with what happened in this case as well as your background and your circumstances. I think obviously it's concerning conduct on your part. It's clearly inappropriate, not something that an adult at your point in life should be engaging in with regard to young minors. And from what I read in the report, the individual involved here, I don't think is currently seeking any kind of counseling, but this is the kind of behavior that can affect kids at that age in a way that you might not anticipate. And so the court, I think, number one, is going to follow the recommendation with regard to probation, because I think it's important that there's some supervision of you and your activities to make sure that you're not going to engage in this conduct again. Because generally this is kind of the first step to something more serious. And I think it's important for us to monitor what you're doing to make sure that you're not engaging in this activity. I can understand, based on your circumstances, how you might have started to go in this direction. I'm hoping that this being discovered and dealt with here in the court system is going to kind of wake you up and make you realize this is not conduct that you can engage in, and it's just completely inappropriate. I don't think that jail time up front is necessary in this case, because I think this is a wake-up call to you based on what I've read in the report, based on what your attorney has said. So I think you are going to take this as an indication that something's wrong and that you need to correct it. So I'm going to give you an opportunity to avoid jail time, although I think this conduct certainly would warrant it. But under your circumstances with no prior criminal history, I think it's appropriate to give you an opportunity to correct your behavior on probation. If you fail to do that, then you will have to serve jail time. The court is going to place you on probation for a period of 36 months. Court's going to adopt as the conditions of your probation all the terms and conditions listed in the report. And that includes not having any verbal, written, electronic, or physical contact with any individuals under the age of 18. It's also going to include the provision that you not reside, work, or loiter within a student safety zone, which is 1,000 feet of any school. That you not be within 500 feet of any parks, municipal swimming pools, playgrounds, child care centers, preschools, and other places that are used by children. The court is going to require that you register with the Sex Offender Registration Act, that you comply with that. The court is going to order that you pay a crime victim's assessment of $130, court costs of $325, attorney fees of $350, a DNA testing fee of $60, a $68 state cost, and a $30 per month supervision fee while you're on probation. The court is going to impose 90 days in the Kalkaska County Jail with credit for 1 day served, that to be held in abeyance to be served at the discretion of the court. I'm sorry, one other provision that I want to highlight, although again, I'm adopting all the provisions recommended for probation, but another one that I want to highlight is that you not have any verbal, written, electronic, or physical contact with the victim in this case, and that you not be within 500 feet of his residence, school, or place of employment. You do have the ability to seek an appeal of this sentence. So you're going to have this knowledge receipt of your
For the record, Ms. Ashton's procedure copy of her rights. Execute the same as returning.
Thank you. Mr. Barrett, does she need to do anything today with regard to probation?
Yes, Your Honor, just one second.
Okay, so just meet with Mr. Barrett, Ms. Ash here before you leave the courtroom, okay? Good luck to you going forward.
Thank you.
All right, I have Mr. Crowe who's not appeared.
Okay, People versus Cassandra DeGroat, case number 244913. This hearing was set for 9 a.m. It's now 9:17. Mr. DeGroat has not appeared here in court today. Have you had any contact with her?
And I reached out to Mr. Crowe, and the last piece of contact that I had where she responded to the text message was asking, have you received a court date? And at that time, I had not received a notice. So I said, well, I have not received a notice. Check with the circuit court clerk. These times could change if you haven't received a notice. I have since attempted to contact her, and her voicemail is one of those ones where it's not currently accepting messages. And then I've sent her text messages, but I haven't received anything. The last thing that I had heard from her is that she was going back to the hospital because she wasn't feeling.
All right, I note that she did. Section failed to appear back in June. The court set this for a show cause hearing today. Based on her failure to appear today, the court finds it to be appropriate to issue a bench warrant for her arrest. So Mr. Ziegler, if your office can prepare that, the court will sign it and we'll proceed further with Mr. DeGroat's case when she's arrested and brought before the court.
Yes, Your Honor.
Thank you.
Your Honor, I do have one other matter later today, and I think it's 11:45 room is for McDowell. So I'll have to come back from family court, but I would just note that at 9:30, Ms. Housel is supposed to be here. I don't know if she will or she won't. I did talk to her in between, and she tried to fill out the application, but for whatever reason, I think there's a misunderstanding about her ability to fill it out. In any event, Your Honor, she filled out the form.
Okay. Thank you. Travis, are you ready with Mr. Armstrong's case?
Yeah.
Okay. All right, is Sarah Helsel here?
Your Honor, she's in the, yeah, Patriot. Your Honor, I did have her fill out an application for assigned counsel.
Okay.
And Mr. Travis was previously her attorney. She still qualifies and I will reassign Mr. Travis. But I was just gonna give Ms. Matley a copy of the application.
Okay, great, thank you. Mr. Travis, have you had a chance to talk to Ms. Helsel at all today? Is she here?
She's right here, Your
Oh,
Honor.
Ms. Helsel, if you come up to the front, let's, I want to call the case. This is file number 23484, People versus Sarah Helsel. And if I could just have counsel for your appearances on this.
Your Honor, to my understanding, I've been appointed and now counsel Kyle Travis on behalf of Mrs. Helsel. I have not spoken with Ms. Helsel in probably a year and a half. We did just briefly chat because I asked her if she had a chance to talk to Mr. Seeger, and then she did talk to Mr. Seeger. So as it stands, I have a vague idea of the charges, but it's been a long time.
Okay. All right, Mr. Ziegler, do people take any position about how we should proceed with this file today?
Your Honor, given that Mr. Travis was just appointed approximately 2 minutes ago, I would not object to adjournment to give him some time to get back up to speed with the file. We can have some discussions about how to proceed.
Okay, so Mr. Travis, I mean, this case has been bound over for a year. So we need to move forward one way or the other. What I'm going to do is get this set on the trial calendar so that we have a trial date out there. I'm going to set it for a next hearing in 60 days for a plea cutoff. So that'll give you some time, Ms. Helsel, to get Mr. Travis up to speed, and you as well, Mr. Travis. I think given the status of the case, that should be more than enough time for the parties to negotiate over any kind of plea agreement, make a decision. Mr. Ziegler, if this does go to trial, how many days of trial do you think that we would need?
Your Honor, I don't think I would have very many witnesses, but there is a lot of documentary evidence. I would err on the side of 2 days.
Okay, so we'll set it for a 2-day trial. I'm gonna set that about 120 days out. And again, the next hearing will be in 60 days, so between now and then, Ms. Helsel, you need to make sure that you discuss any plea offers with Mr. Travis, and at that next hearing that you're ready with a decision about whether you want to proceed to trial or accept a plea offer, okay?
Okay.
And Your Honor, a question, just because I know at one point, I think I requested a competency and criminal responsibility. Those happen? Or was that been moved beyond at some point?
The competency one was done, but not the criminal responsibility.
Okay,
Okay. Well, I guess I'll check, and if we need to, we'll discuss that later as to
Okay.
where the criminal responsibility section is.
okay. All right. And in any case, I mean, that would be something that would really only be relevant if we're gonna go to trial and potential defenses, so that, in my view, that's not anything that would get in the way of Ms. Helsel being prepared to either accept a plea or not. So in 60 days. Okay, anything further, Mr. Ziegler, on this file today?
No, Your Honor.
Mr. Travis?
No, Your Honor.
Ms. Helsel, do you have any questions about how we're going to proceed with your case?
No, Your Honor.
Okay, thank you, that's all for today.
All right, thank you.
People versus Juan Francisco Flores. Campos, case number 244921.
That's my understanding. He is,
Okay. So. Mr. Travis, and
Yes.
I'll explain this to the court officer as well. I don't think it's appropriate to have small children in court. So I'm gonna ask that the children wait outside, please. Thank you. It's not a place for little children. I'm sorry. Mr. Travis, can you put your parents on the record in this file? please?
Yes, Kyle Travis on behalf of Mr. Flores.
Francis.
Thank you. This is the date and time set for sentencing. Mr. Flores Campos, have you had a chance to go through the pre-sentence report and talk to Mr. Travis about that?
I did.
Okay. Mr. Travis, are there any additions, deletions, or corrections to that report?
Not that I'm aware of.
All right. Mr. Ziegler, do the people have any additions, deletions, or corrections?
You're under page 3 of the description of offense narrative. This is first full paragraph near the end. It says the driver was identified as the defendant Francisco Flores Campos. That should read Juan Francisco Flores Campos.
Any objection to that change?
No, Your Honor.
Okay. Any other corrections?
No, Your Honor.
Thank you. Anything on behalf of the people for allocation today?
Your Honor, this is a plea to a misdemeanor, and the recommendation is for fines and costs. I certainly understand there's a presumption in misdemeanor cases that's an appropriate sentence, and that's how they're to be handled. I feel that there's good reason in this case to warrant a different result. Primarily, I say this because the report goes into detail about the defendant's failures on probation. His last term probation in Kent County was a failure, resulted in some violations for failing to follow through. PSI also notes that he's currently absconding on probation from another state. PSI author concludes that probation is not appropriate due to those prior failures on probation, that he's not likely to be successful on probation, and therefore recommends fines and costs. To my eyes, Your Honor, that makes it look like we're rewarding him for not being a good candidate for probation by simply giving him fines and costs. In my view, the spectrum of punishment should trend upward and not downward, whereby if he's deserving of a probationary sentence in this case, which I think at a minimum he is, but he's not a good candidate, he's unlikely to be successful, we shouldn't then give him a lesser sentence of simply fines and costs, but instead we should consider a greater sentence. Also, just in terms of the facts of this case, Your Honor, I would argue that the conduct involved is fairly concerning. This is a case where the defendant was traveling at incredibly high rates of speeds, according to PSI, well over 100 miles an hour. He was running red lights. He was passing other motorists on the right-hand side of the road. The court also indicates at one point that the defendant stated he did not stop because he doesn't have any brakes on that motorcycle. That's an incredibly dangerous circumstance, both to himself, to the officers that were involved in pursuing him across 3 counties, and to other motorists on the road who were just innocent bystanders and were endangered by the defendant's conduct. This chase led through 3 counties, and the defendant could have ended this pursuit at any time. This is a 1-year misdemeanor. I understand the recommendation of court costs and fines, Your Honor. But I would ask the court to consider sentencing the defendant to a term of incarceration for a period of time, as his conduct and his history warrants sending a message both to him and to the community at large that it's not acceptable and worth attempting to flee from law enforcement, and that the penalties will be more than simple. Thank you.
Mr. Travis.
Thank you, Your Honor. Your Honor, we would obviously ask the court to follow the recommendation. I understand many of the things the prosecutor has pointed out. I would note, though, that there are still rather severe sanctions from the Secretary of State, even for this conviction, the misdemeanor version. Can't have a license for over a year. He's also generally doing fairly well, being a good citizen. He's got a business where he does construction. He has a family. He's obviously got support from his family. He has participated in the process as he's supposed to. I understand the lack of belief that he will do well on probation. I would counter that and say that my interactions with him through this case would indicate he could do well on probation. He has been responsive, he has appeared in court, he has done the things he needs to do, but I also understand that his history doesn't necessarily support that kind of recommendation for probation, but I do think he could do it. So if the court did feel that fines and cost was not appropriate, I would ask the court to consider maybe placing him on probation. Thank you.
Thank you. Mr. Flores Campos, was there anything that you wanted to say today?
Yes, Your Honor. It was a mistake, what I did. Yeah, I was scared. Yeah, for me, I'm done with motorcycles. This is it. I'm really sorry for what I did on this county, because I'm not from this county. I was just passing through, getting a job site. I was just trying to get to the job site. That was it. But everything went wrong. So now I'm here. And now the consequences. I would love to go back and keep going with my life. It's been hard for the last 3 years. So if I'm here, it's the result of something that I did. I'm ashamed of it.
Okay, thank you. I did read through the report, so I'm familiar with what happened in this case. I'm also familiar with your background and circumstances based on the information in that report. And, this is very concerning, what your actions in this case. You put yourself at danger, certainly. And as someone with a family, that's not something that you want to do, because you could have easily been seriously injured or killed during this police chase. But you also put innocent people in the community at risk who had nothing to do with you or your circumstances. And certainly the police officers were placed at risk, not only during the chase, but in your actions afterwards in resisting the police officers. And none of that had to happen. If you had simply pulled over, maybe you would have got a traffic ticket or something. But you turned what could have been a really simple situation into something much worse. And you add that to the pending matters that you have in this state and elsewhere. I don't think you're a good candidate for probation. You haven't done well on that before.
May I explain those problems that I have in other state?
It really doesn't matter. The records are what they are, and you have warrants, and you can fight those warrants if you think there's not a basis for them. But in my view, the records are what they are. Also, in terms of a Secretary of State sanction, I don't think, I think you've shown that you're going to drive whether you have a license or not. So I don't think that sanction really has any teeth to it. And I don't think probation is appropriate. I think it would, frankly, I think it would be a waste of the resources here in the community, given your past performance on probation. I do think that we have an interest here in discouraging this kind of conduct and making people aware that if you're going to run from police, and then if you're going to fight with police, there's a penalty for that, that there's a consequence to it. And I think fines and costs is not adequate to address that. So the court is going to sentence you to a jail sentence. The court is going to sentence you to 6 months in the Kalkaska County Jail. You do have credit for 2 days served. The court is going to order that you pay a crime victim's assessment of $130, court costs of $325, attorney fees of $350, and $53 state costs. Because this is a misdemeanor, there are no written appellate rights. But if you did want to appeal this sentence, you would have to seek an appeal within the next 21 days. If you have more questions about that, Mr. Travis, your attorney, would be able to help you with that. Mr. Ziegler, anything else that we need to address today?
Very much.
Mr. Travis.
Nothing further on.
Mr. Flores Campos, you are remanded to the custody of the county at this time. Travis, do you have Mr. English present?
Mr. English is in custody and Mr. Horowitz not going to address status of that.
In our jurisdiction or somewhere else?
I believe he's in our jurisdiction.
Are we gonna, we haven't read it, or is he gonna be? Why don't you guys tell me what we're gonna do?
So, Judge, I had filed a substitution by mail a couple weeks ago, but for whatever reason, it hasn't been registered. I don't know if it's because you didn't have the consent of Mr. English, but it was basically an MIDC reassignment.
Okay,
But that said, I showed up at about 9 to speak with Mr. English this morning here, and he's not here. So I wasn't aware that he was going to be here by Zoom, so I don't really have any contact with him. I don't know why he's appearing by Zoom versus coming here in person. I don't really know what the story is there.
all right, why don't we, it's right now, so let's bring him up on the screen here.
Alrighty. Take the computer down to Mr. English.
Okay, great, thank you. All right, sir, are you Michael James English?
Yes, I am.
Okay, we're on the record in People versus English. This is case number 244923 and 4925. The record should reflect Mr. English is present by video from Wexford County Jail. If I could have counsel put your appearances on.
Ryan Ziegler on behalf of the people, Your Honor.
Michael Horowitz on behalf of Mr. English.
Okay, so Mr. Horowitz, you were, before we came on the record, you were indicating that you've recently been reassigned to Mr. English's case. Is that correct?
Correct, Your Honor. I don't know the reasons for the reassignment. I just know that I was asked, and Mr. Travis sent me a substitution. I signed it and I filed it by mail. And so it should be in a file somewhere, but I haven't seen it change on the docket. I haven't met with Mr. English yet. I had arrived here somewhat early to meet with him this morning at the Kalkaska County Jail, but was informed that he wasn't here. So at this point, I don't have contact with him, and am not sure what I can accomplish at today's hearing.
All right. Do you want the court to reset this so that you have an opportunity to speak with him?
I think that would be the best course of action, yes, Judge.
Mr. Ziegler, do you have any objection to that?
No, Your Honor. I don't.
All right, Mr. English, were you able to hear that?
Yeah.
Okay, so we're going to reset this hearing. Mr. Horowitz is your counsel. He's going to be in touch with you about how to proceed with each of your cases, okay?
Okay.
Do you have any questions?
Yeah, because the thing is, if my previous attorney that I did have would have done what he was asked to do, it would have never been brought to your court in the first place. It would have been dismissed prior to this, so that's why I fired him.
Okay.
Here nor there, I think.
Well, you'll have an opportunity to speak with your new attorney, and I'm sure he'll take appropriate steps to address whatever issues you have with your case, okay?
All right.
Okay, Mr. Horowitz, anything further today?
No, Judge, thank you.
Okay, Mr. English, we're gonna disconnect, but Mr. Horowitz, your new attorney will be in touch with you, okay?
All right.
Thank you.
Thank you.
Mike, what's your P number?
81489. Thank you.
People versus Stover, case number 244924.
Kyle Travis on behalf of Mrs. Stover.
Okay, Mr. Travis, can you tell me where we're at with this file, please?
Yes, Your Honor, I believe this is our first appearance in circuit court. We did waive a preliminary exam. Part of that waiver was that the matter would be referred to sobriety court. And speaking with Mrs. Stover and sending out some emails to sobriety court staff and speaking with Mr. Ziegler, I don't think she's been evaluated yet or interviewed. But she does want to pursue that. So we would ask the court to grant us an adjournment. So hopefully she can make that evaluation. She is local. It would be a Kalkaska County sobriety court situation if that was possible.
Ziegler, any objection to that?
No, Your Honor, I would just note that I did do a referral. We have a meeting this afternoon and I hope to discuss it at that meeting. Answer one way or the other.
Okay, so I'm gonna set this for status conference plea hearing in 30 days. And at that point, Ms. Stover, you need to make sure that you follow through with everything that the sobriety court needs to determine whether you're eligible or not. And Mr. Travis will need to either have that in place or move forward, setting it for trial at that point, okay? Do you have any questions, Ms. Stover?
I was just wondering. I'm blown twice a day, and I'm just wondering, because my money situation is tight right now, because I'm not getting a job right now until I figure out where this is going, because I don't want to start a job and then end up in jail or not be able to finish it, because that's foolish on my part. I don't want to, I just want to do what I want to do. I was wondering if I could drop one blow a day.
We're gonna leave things where they're at until we find out about the sobriety court and get things more in place, because I want to make sure that you're being tested and that you're staying clean.
That's fine, that's fine. I just saying about the money, but I can handle it until we get that straight.
Yeah, okay.
Thank you.
Yep, you're welcome. Thank you. Mr. Horens here?
Yes, Your Honor.
Okay, People versus Horens, case number 244911. If I could have counsel put your appearances on in this file, please.
All right, so you're okay. Your Honor.
Kyle Travis on behalf of Mr. Horowitz.
Mr. Travis, can you tell me where things are at with this case?
Yes, Your Honor. Your Honor, we have adjourned this matter before. The situation is similar to Mr. Horowitz is trying to get into sobriety court, but he lives down in Belleville. We have made progress as it stands, and it was slow progress. And it's, as I was discussing with Mr. Ziegler, it's become a little bit more complicated to do a transfer now than it was before, or maybe better. I don't know, depending on how you look at it. But two different courts in Wayne County I've spoken to, and probably the most optimistic is the 34th district. They've been the most willing to work with us. Part of the problem is apparently in Wayne County, they handle sobriety court differently. The district courts generally take seconds. Generally, it's a plea from a third to a second. But I've spoken with the probation officer there. She's spoken with her judge. Mr. Ziegler has indicated he would offer a 1-year delay rather than the standard 2-year delay that Kalkaska Sobriety Court works on. The judge on the 34th said yesterday to their probation officer, they would accept that, but what they want to do is reach out to SCAO and make sure, given the way their program is set up, because they generally don't take thirds in, that would be applicable, acceptable to SCAO. If SCAO says yes, it sounds like the 34th would take Mr. Horens. The 23rd is another court, we're a step behind. That probation officer initially said, no, that won't work. But then on further, actually, Mr. Horrocks reached out and talked to him, and he contacted me back and said, well, maybe. He similarly has a meeting tomorrow, I think, and said, well, let me ask our judge. So we have two prospects. One that is literally, if SCAO says yes, they're saying that they would take him into their program. So in light of that, I know that the case has been around for a bit, but we are very close. They would ask for another adjournment.
Mr. Ziegler?
Your Honor, I have, given that there's been some progress made on this front, and I've been discussing this regularly with Mr. Travis. If we get the upvote from scale, I think we're just ready to go on that. So I would ask the court to give us another 30 days, just so that we can confirm that and get into that program.
Okay, so the court will set this over one more time. That's gonna be the final adjournment, though. You know, if this is gonna happen, it needs to happen in the next month. So we'll set it for another hearing in 30 days. Mr. Vargas, I think we do need an updated address for you because I'm just looking at the file. It looks like we keep getting mail returned.
Yes, Your Honor, I'm going right next door and taking care of that.
I think we could.
Yeah.
right now.
Or if I can do it
You
here.
can do it right now.
Yep. My new mailing address is P.O. Box 45, Keewaydin, 49648. Thank you.
All right, thank you. That's all.
Thank you so much.
And is Mr. Wisnatus here? Mr. Wisnatus, yeah.
I believe he's would be on the screen.
Do you know how you're anticipating that case to proceed today?
Yes, Your Honor. So we had adjourned Mr. Wisnitis to actually look at other matters, but after court last month, I got an email from an MDOC probation officer from Genesee County who wanted to refer Mr. Wisnitis to their sobriety court. We had an intake meeting yesterday.
Okay, that's fine. I'll let you go in more detail once I just wanted to know if we were gonna have a plea or not, so. Okay. All right, I don't see him up yet. We're a couple minutes ahead, so let's take a short recess. We'll come back on the record in about 5 minutes. Okay, we have Mr. Wisnitis connected. This is People versus Wisnitis, case number 244914. If I could have counsel put your appearances on in this file.
Brian Ziegler on behalf of the people, Your Honor.
Kyle Travis on behalf of Mr. Wisnitis.
Okay, Mr. Travis, can you tell me where things are at with this file, please?
Yes, Your Honor. After court last month, I was reached out by Genesee County MDOC probation officer who suggested that Mr. Wisnitis pursue sobriety court in their county. After some discussions with Mr. Ziegler and Mr. Wisnitis, he is pursuing that. He had his interview and intake yesterday to get into that program. So our request would be for an adjournment because previously we had not really even explored this as an option, but it is out there and all parties seem to want to see it happen. It probably would be for the best. And he will find out probably Monday or Tuesday whether he's going to be accepted into the program or not.
All right, Mr. Ziegler.
I have no objection to another 30 days.
Okay, so as with the last case, this is going to be the final adjournment. So if we have that set up, that's great. We can enter a plea on that basis next time. Otherwise, we'll either have to enter some other type of plea or the court will set it for trial. Mr. Wisnitis, do you have any questions about how we're going to proceed with your case?
No, Your Honor.
Okay, so essentially over the next 30 days, if the sobriety court option is going to happen, it needs to happen within that period of time. So you need to make sure that you continue to communicate with them and with your lawyer, okay?
Yes, Your Honor.
Okay, Mr. Travis, anything further on this case?
Nothing further, Your Honor. Thank you.
Mr. Ziegler.
No, Your Honor.
Okay, Mr. Wisnitis, you're free to disconnect at this time.
All right, thank you.
Thank you, Your Honor.
People versus George Armstrong, case number 244900. If I could have counsel put your appearances on.
Brian Ziegler on behalf of the people, Your Honor.
Robert Curry, on behalf of Mr. Armstrong, Your Honor.
All right, this is the date and time set for sentencing in this matter. Mr. Armstrong, have you had a chance to go through the pre-sentence report and talk to Mr. Curry about that?
Yes, Your Honor.
Okay. Mr. Curry, are there any additions, deletions, or corrections to the report?
Judge, I have two additions. I tendered a copy to the prosecutor and also to the Department of Corrections. One's a update on his counseling and pathways, and two negative drug screens from June. And also I have a letter from his doctor that specifies that he has some serious cardiological problems, and he's his blood pressure as of 6/28/2024 was 210/110. So I can tender this to the court.
Yeah, you hand those to the court officer. Just give me a moment.
Oh, thank you.
Okay, did you want these attached to the PSI?
Yes, sure.
Any other additions, corrections, or deletions?
No, Your Honor.
Are there any challenges to the scoring of the guidelines?
No, Your Honor.
Mr. Ziegler, do the people have any additions, deletions, or corrections?
No, Your Honor.
Any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocution today?
Yeah, Mr. Armstrong is before you for possession of analog beds. Normally, I would not be standing here asking for a jail sentence for offense of that level. However, Mr. Armstrong has demonstrated that he will not comply on probation because he has failed dismally on bond. He's continued to test positive for cocaine metabolite while on bond. He tested positive in January. He tested positive twice in April, on the 11th and the 18th. He tested positive again on May 16th after a couple of negative tests in between. That suggests to me that he's used cocaine on at least 3 separate occasions while on bond for what was originally a possession of cocaine offense. People agree completely with the PSI author. The defendant is not taking appropriate responsibility for his actions. He's minimizing his conduct and he is disobeying the court's bond order. As such, he should be sentenced to a period of incarceration as probation is unlikely to be successful. Given that his guidelines in this case are 0 to 11, and given how flagrant his continued use has been, I would ask the court to sentence him to 6 months jail. Mr. Armstrong has no one to blame but himself for that recommendation, and he richly deserves that punishment due to his continued violation of this court's order on bond. Thank you.
All right, thank you. Mr. Curry?
Yes, Your Honor. I have really no objections with the pre-sentence report. I think it was well written, Judge. Says he was courteous and cooperative, and did test positive when he was out on bond. I agree with that. And when I confronted Mr. Armstrong on that, I sent him to the counselor. I tried to get him to the drug court. I couldn't get him in, and they recommended pathways, and I told him to double up on that to show the court that you have an intent not to use in the future. Now, he does have a past record, and as the report indicates, it was mainly cannabis related. He never had an issue with cocaine till recently, Judge, and he does have 500 acres. He has his mother in the courtroom. She's 79. They run the farm together. And they have a good business. For the last 36 years, they've been driving to Traverse City and working the farm market on the weekends. And he was going through this area because he has a 2016 Freightliner sponsored by Ski-Doo, and he has 5 snowmobiles. Because I asked him, "What are you doing over here, George?" He says, "I'm over here because I race every year, and I was showing this new girlfriend the tracks, and he got stopped on the way." And not with that girl anymore. I think he's trying to impress her, but he's addressing his issues, Judge, and he is a productive citizen. He pays his taxes. He even went out and just bought a new Corvette. I mean, the guy's productive and he's hardworking. Obviously, he didn't take it as serious as he should, made mistakes. And he's assured me in the future it's not going to happen again, Judge. He spent a lot of money on this too. I mean, he's been testing on the Silver Link. I think he's got $2,400 into that. He's realized that that's not something to deal with. And I've also told him, "George, at your age, I'm 70 years old, Judge. At 62, he shouldn't be messing with that stuff. It's like he doesn't have a heart attack." So I'd ask the court to take into consideration. I know jail is recommended. I'd ask the court maybe to, if you give him jail, if you give him imposed jail in this case, to maybe consider holding some of it in advance. I think he will successfully complete probation. I've been doing this for over 40 years, Judge, and I read him pretty good. I don't think he's going to have any problems in the future. Thank you.
Thank you. Mr. Armstrong, was there anything that you wanted to say today?
Sure, I just, learned my lesson and realize what I got to live for and be honest person,
All right. I did read through the pre-sentence report, so I'm familiar with what happened in this particular case, what brings you before the court here today. I'm also familiar with your background and circumstances based on the information in that report. And certainly, yeah, your conduct while on bond is concerning. Apparently you've got some serious health problems, and for no other reason, you should. Cocaine is certainly not the kind of substance you want to be using when you have high blood pressure and heart problems.
Yes, sir.
And so, you know, I know there's indications in there that you don't have a substance use disorder with regard to the cocaine use, but the fact that you're, you know, continuing to use that in spite of health problems, I think is an indication that there may be an issue there that you need to address and get some help with, because I think you're having a hard time doing that on your own. With regard to the appropriate sentence in this case, the possession is concerning, the fact that you were operating a vehicle, apparently after having recently used cocaine and with alcohol in your system, you presented a danger to everybody else on the road, including yourself and your passenger. And your performance on bond, I think, does warrant a penalty in this case. The guidelines are 0 to 11 months. I think a jail sentence is appropriate to address your wrongful conduct and hopefully to deter that in the future. I find that a jail sentence of 6 months is appropriate to address your conduct. And so the court is going to sentence you as to count 3, which is the possession charge, to 6 months in the Kalkaska County Jail. You do have credit for 2 days served. A crime victim's assessment of $130, court costs of $325, a DNA testing fee of $60, and a $68 state cost. On the charge of operating with the presence of a controlled substance. Again, 2 days in the Kalkaska County Jail with credit for 2 days served and a $53 state cost on that charge. You do have the ability to seek an appeal of this sentence. We're going to provide you with some papers that explain to you what your appellate rights are, as well as how to request a court-appointed lawyer to help you with an appeal. Mr. Curry, if you could have Mr. Armstrong acknowledge receipt of those appellate rights. Thank you. Mr. Armstrong, you're remanded to the custody of the county at this time.
We're gonna go back down that hall, please. Right door, stay to your right, please.
Okay, our next hearing is set for 11:15, so we'll be in recess until that time. Okay, we're on the record in People versus Brian Carley, case number 234873. If I could have counsel put your appearances on, please.
Brian, say what, yeah, Your Honor.
Craig Hamel on behalf of the defense, standing in for Steve Hamel.
Okay, thank you. This is a date time set for sentencing in this matter. Mr. Carley, have you had an opportunity to speak with your attorney and to go through the pre-sentence report?
Yes, Your Honor.
Okay. And Mr. Hanel, I know that we need to correct the jail credit. That should be 77 days. That's incorrect on my report at least. Are there any other additions, deletions, or corrections?
No, Your Honor.
And are there any challenges to the scoring of the guidelines?
No, Your
Honor. Okay. Ziegler, do the people have any additions, deletions, or corrections?
All right, that might be looking at our old copy, but just the sentencing date in the top right corner on the face sheet. That's 5/24.
Okay.
And then just by way of the passage of time, I believe the Kent County case is referenced under pending charges as resolved. I suspect defense counsel knows a little more about that.
That's correct. Is it?
Your
already been
Honor,
sentenced on that
he's
one?
serving a 6-month sentence with 2 years probation.
Okay, so the report should be amended under pending charges to indicate that those have been resolved. Any other corrections, Mr. Ziegler?
No, Your Honor.
And do the people have any challenges to the scoring?
No, Your Honor.
Anything on behalf of the people for allocation today?
Your Honor, I think just based on how long it's taken for us to get the sentencing, we've gone from a point where we were hoping that Mr. Carley would get into the sobriety court or drug court down there to now where he's not been deemed eligible for that. And in fact, he's already been sentenced down there to a 6-month sentence as well as 2 years of probation. Given how this case has proceeded, I don't really see that there's a lot more that we would accomplish by stacking on additional terms of probation or additional incarceratory sentences. He'll be adequately punished and monitored down in Kent County. So for different reasons, Your Honor, I still think the recommendations contained in PSI are appropriate to simply give him fines and costs and send it back to Kent County. So I would ask the court to adopt those recommendations.
Thank you. Mr. Hanel, anything on behalf of your client today?
Your Honor, as the court could see in the report, Mr. Carley had lost his wife unexpectedly at 33 years. His life is spiral after that. He's an engineer with Stampede. He's got strong support from his employer. In fact, his employer called me about this. I know him. And he's one who will step in and help employees when they have problems with substance abuse or other issues. It's been the case with Mr. Carley as well. He speaks very highly of him. He's a critical engineer. He's an engineer there, and his position is critical. He's struggling. He's trying his best. I think the 6 months that he's doing is giving him a perspective of where this can go.
Okay, thank you. Mr. Carley, anything that you wanted to say today? No. I did read through the report, so I'm familiar with what brings you before the court here today, and the charges here, as well as your background and circumstances based on the information in the report. And you know, it does seem that you've had an unfortunate run here in the last few years. It's resulted in some issues with substance abuse, and I hope that you do get help with that so that you can move forward and continue to lead a productive life. You do have a lot of things going for you if you can get a hold of this problem. I don't think that additional sanctions are warranted in this case. I think the 77 days that you've served on this charge is sufficient, in addition to what you're facing in Kent County, to address your conduct in this case and hopefully to correct that going forward. So the court is going to sentence you to 77 days in the Kalkaska County Jail with credit for 77 days served, a crime victims assessment of $130, court costs of $325, and a fine of $500. You do have the ability to seek an appeal of this sentence, and we're going to provide you with some paperwork that explains what your appellate rights are. Mr. you know, if you can have Mr. Carly just acknowledge receipt of those, please. Mr. Ziegler, is there anything else that we need to address on this case? Mr. Hano?
No, Your Honor. Appreciate it.
Mr. Carly, good luck to you going forward. Thank you, Your Honor.
My son, they asked you to thank you for your patience in this matter.
We've had some issues that have been more the fault of a different entity than any of us, so thank you for that.
Thanks, guys.
Can they bring them out?
Yes. All right.
You ready for Mr. Garlaro?
Yes.
Okay.
Well, actually, is Mr. Horowitz here?
Well, I don't know that. He's not passing, right? Actually. No worries.
We'll kind of see.
Thank you. Yeah, we're waiting. Yes, Mr. Horowitz.
So you ready on Mr. Galarno's case?
Yeah, sure.
Mr. Galarno, if you can go right to the podium there, please. We'll go on the record in People versus Galarno. This was case number 214552, 224645, 244885, and 244916. The record should reflect that Mr. Galarno is present here in the courtroom. If I could have counsel put your appearance.
Michael Horowitz on behalf of Mr. Galarno.
Thank you. This is the date and time set for sentencing in this matter. Mr. Galarno, have you had an opportunity to go through the pre-sentence report and talk to Mr. Horowitz about that?
Sure, yes, I have.
Mr. Horowitz, are there any additions, deletions, or corrections that need to be made to that report?
To the scoring, Your Honor, if we're ready for that.
So let's start with the report itself. Are there any additions?
No, Your Honor. Thank you.
What are the challenges to the scoring?
PRV 2 is scored throughout at 30 points. That would be based on having X amount of low severity prior felonies. I believe that Mr. Galarno is largely gapped, other than the one prior that he is presently on probation for. That's one of the files included today. So I think PRV 2 would be scored with 5 points, which would subtract 25 points from the PRVs, and I think drop it down to D level.
All right, so it's prior low severity felony convictions, and it's currently scored at 30 points, which would be 4 or more. So how many are you saying there are, Mr. Horowitz?
I believe 1, and that anything else is gap.
Mr. Ziegler or Ms. Wagner?
Your Honor, I'm looking at it. I can come over to the court and, this is just first being brought to my attention. Mr. Horowitz has had this report for some time and just bringing this up, so I didn't have time to prepare for that, but in brief, looking at it, I don't see a 10-year gap. If that's what he's referencing to, he's got 8 prior felonies with the 4, or the 30 points being scored. Appears appropriate.
All right, Mr. Horowitz.
Item 9 of 12, discharge 2007. Item 10 of 12 is offense date 10/2020. That's a 13-year gap.
Why don't we let's just take a short recess, Ms. Wagner. I'm going to give you an opportunity if you want to come over here and talk to Mr. Horowitz, see what he's looking at, and I'll give you guys an opportunity to take a look at this. So we'll take a bit of a recess. While we're doing that, is Mr. McDowell or Mr. Rogers present? Both of you are? Okay, great. Stigler, you mind if we move on to those 2 cases while they're waiting? Okay. The court will call People versus Rogers. Case number 224726. Mr. Rogers, if you can come right up to the podium, please. Record should reflect that Mr. Rogers is here today. And I know you were previously represented by Mr. Slocum.
Yes, sir.
Are you okay with moving forward today?
Yes, I talked to him, said he didn't really have to be here.
Yeah, okay. I just want to make sure you're comfortable with.
Yes, I'm perfectly comfortable with Your Honor.
Okay. Mr. Ziegler, is there anything that we need to address from your side of things on this case?
Your Honor, just to congratulate Mr. Rogers for doing an excellent job on the sobriety court. He's complied with everything the program required of him. I think he's made great strides towards addressing the substance abuse issues, and he's well deserving of the court's reduction from my 3rd to my 2nd day.
Thank you. Mr. Rogers, is there anything that you wanted to say today?
Well, I appreciate the program. Sometimes that's what it takes, a long-term thing to help a guy out, and it seemed to work pretty well for me. It was a long struggle. It took a while to give into it, but I guess that's why it's lengthy. So it's helped me and my family out a lot. I know I see my family more. It was good all the way around. I fought it at first, but like I said, but, it really wasn't that long of a program after you're in it, but it seemed like, it was the end of the world to start with. But things have been going good, and doing a lot of things with the family now and grandkids, and so I appreciate you guys' offering the program to me. It was well deserved for me. Worked well.
Good. And I presided over the sobriety court for a number of years. I know it's not an easy program to get through. I get what you're saying, especially at the beginning. It's a lot of adjustments. There's a lot of requirements. It's very robust in terms of what you have to comply with to maintain your participation. So I know it's not easy, and I know it takes a lot of dedication on the part of the person going through it. And what you said strikes me in particular is that, you finally gave into it, and the people that are successful in that program generally are the ones who decide that they want to do it for themselves because it's going to give them a chance at a better life moving forward. And it sounds like that's what happened.
It worked real well for me.
Yeah. So I do think you should be proud of yourself for completing that program and for that accomplishment. I hope that gives you confidence going forward, and that you can maintain where you're at now.
Yep.
And I certainly hope that for you. I think, on behalf of the whole community, it's in our best interest that you're remaining sober, that you're moving forward with your life, because the community as a whole is in better position, and then you certainly are on an individual level. So congratulations, and I hope you continue with that. I'm happy to sign your successful discharge, and you're all set.
Thank you, Your Honor. I appreciate it.
Thank you. Good luck to you going forward. People versus McDowell, case number 224746. Okay, the record should reflect that Mr. McDowell is present here in court today. And Mr. McDowell, I know that as with Mr. Rogers, you were previously represented. And, oh, Mr. Seeger, you're here on behalf of Mr. McDowell.
Yes, sir.
Great. Mr. Seeger, is there anything that we need to correct or address for the record?
No, Your Honor, at least as I understand it, he is successfully completed his Supreme Court. It's definitely a plus for everyone.
Thank you. Mr. Ziegler, anything on behalf of the people today?
Your Honor, I have very similar things to say about Mr. McDowell. We had a couple people come in right around the same time. There was one other individual. They all did great in the program in particular. Mr. McDowell complied with everything he was asked to do on the program. He passed everything with flying colors. To my recollection, I'm not even sure if he had a violation the entire time. So he was a model candidate on the program. I think he's made great strides in addressing substance abuse issues. I don't expect him to be a problem going forward in the community. And I think he's very much deserving of reduction from his OWI 3rd to OWI 2nd today.
Thank you. Mr. McDowell, was there anything that you wanted to say today?
Yeah, I just want to give the court, thank you so much for giving me the opportunity. I was down, it was bad, I needed this. I mean, things happen for a reason. But this has been great. My kids love me now, my grandkids, I can be around people. I've changed jobs, I just have a better outlook. I just look at things differently now. Like I said, John said, it's a hard program, but you have to give in 100% and you have to be willing to do it. And I just want to give the court, thank you for letting me have the opportunity to try this and do this.
Thank you. And as I told Mr. Rogers, on behalf of the community, we appreciate the effort that you put into it. Because again, it benefits us as a whole to have you out there remaining sober, not putting others or yourself at risk, and just living a more productive, happier life. And it sounds like that's what you're moving on to. As I told him, you should be proud of yourself. It's not an easy accomplishment. It takes a lot of work. It takes a lot of perseverance, it takes a lot of dedication on your part to the program and to yourself, frankly. And over that period of time, I think you showed that in successfully completing it. And I hope that it also gives you confidence for going forward, that this is something that you put behind you, and that's not going to be an issue. So congratulations to you as well. I'm again happy to sign the successful discharge, and I wish you all the best going forward.
Thank you, sir.
And we'll just go off the record for a few minutes until we're ready to go forward on Mr. Flores. Okay, we're back on the record in Mr. Garlaro's cases. I believe that Ms. Wagner, on behalf of probation, had an opportunity to address the things raised by Mr. Horowitz.
I did, Your Honor. So for the 3 SIRs, for the first one, the receiving and concealing firearms, PRV 2 should change to 5, with a total PRV of 27, a PRV level of D, making the guideline range 5 to 23.
Okay.
On the delivery, it is the same for PRV points, we'll go to 5. With total PRV being 45, making it a D level. Guideline range is 51 to 85.
Okay.
And then I'll do assault with intent to do GBH less than murder. The PRV 2 goes to 5. PRV 45 points for a level of D, within the guideline range of 34 to 67.
Okay, and then I have one more.
That last one, Your Honor, I believe was attached because it's his underlying probation case. So we could probably just strike that. I think it was just attached with the initial PSI. That was an update.
No, there's 4 counts.
Yeah, there's, because we have
There's
that's
a firearm possession by the felon that was from the drug file.
right.
Oh, okay.
But that one obviously would be 5 for PRV 2.
Correct. Correct.
45 level D, and do we know what that?
It'll go 5 to 23.
5 to 20. Okay.
It'll be at that D level.
Sure, I have all the corrections.
Your Honor, if I may. Oh.
Just a second, I'm gonna give you a chance, okay? We need to go through everything to make sure it's all right. Okay. Mr. Horowitz, are there any other corrections to the scoring guidelines?
Not that I see, Your Honor. I think that takes down the ranges as described. The total number of points, I think, on the delivery charge would be total number of PRV, I think would be 37, but that's the same range. I think there was just it'd still be a D2. So no other corrections, and I agree with the ranges as they've been set forth now.
Right. I just want to make sure what you just said. We have the SIRs correct. So you were saying the point total.
It should be 25 less on each of them, Your Honor.
Right.
So.
Okay. I'm not gonna worry about the math as long as we agree that it's 25 less and we agree on what the range is.
I think we all agree that they're supposed to be level D PRVs.
Okay.
For each of them.
That's correct. Thank you.
Okay. All right. Mr. Ziegler, do you have any additions, deletions, or corrections?
No, Your Honor.
Do people have any challenges to the scoring?
No further issues with the scoring.
Do you have any victims that wish to address the court today?
I believe Ms. Garlaro would like to address the board.
All right, Mr. Garlaro, if you can be seated there, please. Come right up to the podium, please. And ma'am, you're Samantha Garlaro, is that correct?
Correct.
Okay, what is it that you would like to say?
Okay, Your Honor. No, he's sure, so, I would like to state Gabriel has not always been like this. Not mistaken, don't mind right there. Gabriel and I have been married, or been together and married for 7, or been together for 11 years and married for 7. We've had 4 children, and one of them we lost at birth, and it was extremely rough for us. And things started to change. That's affected us with our loss. Eventually, drugs became in the picture, and it was, and it started changing more and more. Gabriel has a big heart, and he has helped so many that were in need without even thinking twice. He's a great father and loves his children dearly. But the drugs became the problem and started taking over. He truly needs help with the addiction, and if he could get that help, he would be able to think more clearly on the choices he made. And I know he could. I have faith in him. He's a great man, but made some horrible choices due to the drugs. But if he can only get clean, it's a lot better. Thank you.
Thank you. Anybody else that wishes to address the court today, Mr. Zibla?
No other victims, John.
Anything on behalf of the people for allocution?
It's difficult to find a place to begin in doing this elocution. I suppose that the first case that started this whole thing is a good place. Mr. Garlaro was sentenced in the original file 21-4552 FH on November 21st, 2022. At that time, he was given 12 months probation, fines and costs, 90 days jail held in abeyance. I recall that sentencing, and I recall the court stating on the record at the time that Mr. Garlaro had had a long period of being relatively crime-free, and that the court would give him an opportunity at that time to demonstrate that he could remain crime-free. As the court is well aware, as reading the PSI in this case, that clearly did not happen. At that time, he was already on bond in file 224645 FH for another receiving and concealing charge, which he committed while on bond for the first offense. He subsequently committed the other crimes charged in files 4885 and 4916, all while on bond and all while on probation. These were by no means minor or insignificant crimes in terms of the delivery of methamphetamine. He told detectives that he had traded Scott Munsell approximately 10 grams of meth for a stolen firearm. He further stated to law enforcement that he was selling or trading 2 to 4 ounces of meth every single week. He also had numerous items he suspected to be stolen in his possession, including several firearms, which he well knew he was not allowed to possess, as he was still on bond for a charge of being a felon in possession of a firearm. To make things even worse, after being on bond for that string of offenses, he assaulted his wife, Samantha Garlaro. Her injuries were significant, and strangulation was involved in that offense. She stated that she thought she was going to die as a result of the defendant's actions at the time. Without beating a dead horse too much, Your Honor, it's clear that the defendant is deserving of a lengthy prison sentence. He's a danger to himself, he's a danger to his wife, and to his community. He's not only been bringing significant quantities of methamphetamine into the area, but also by his behavior in trading methamphetamine for stolen property, has encouraged rampant larceny in the community. He has been given a significant benefit by virtue of his plea agreement in this case, but that should not constrain the court from viewing his course of conduct in the totality of the circumstances, especially when much, if not all, of that criminality was committed while on bond, while on probation. The guidelines for this offense, I believe with the new scoring, are somewhere in the range of 51 to 85 months. It should go without saying that whatever the correct scoring of the guidelines are, Your Honor, I think the defendant deserves the very maximum of that guidelines range. Even viewing the delivery offense just in a vacuum, it was a delivery of a significant quantity of methamphetamine. It was in exchange for a stolen firearm, and it was a firearm he was not even legally able to possess due to being a felon. It was done while on bond for receiving and concealing other stolen property, and while he was on probation. And to make matters worse, he admits that that delivery was part of a string of a larger picture of deliveries whereby he was bringing 2 to 4 ounces, or in other words, 50 to 100 grams or so a week of methamphetamine into the community. That is a level of methamphetamine trafficking that I have not prosecuted in quite some time. It's a significant amount, Your Honor. As to the other offenses, for similar reasons, people would ask the court issue prison sentences on each of them and issue them at the higher end of the guidelines range. There's simply no redeeming or mitigating factors at play in these cases, and the defendant deserves every single month under the guidelines that he has earned. Court also has discretion to sentence consecutively. People leave the decision on consecutive sentencing to the sound discretion of the trial court. And we would only note that he is eligible for consecutive sentencing on each of the 3 files, as he was on bond for 1 or more felony offenses at the time he committed each of them. Regardless of whether the court sentences consecutively or not, the people would request that the sentence reflect the severity of the defendant's conduct at issue in these files, the flagrant disregard for bond, for probation conditions in each of these files, and the significant danger his conduct posed to the victims in particular and to the community more broadly. He deserves the maximum on every single file, and I can think of no reason why the court would give him anything different.
Mr. Horowitz, if you and your client could come to the podium, please, and then Mr. Horowitz, anything that you want to say on behalf of your
Judge, thank you for the opportunity. You know, looking at the sum total of charges and the overall pattern, it's really easy to kind of think of Mr. Garlaro as, you know, some sort of criminal mastermind, right? That he's this linchpin and this, you know, methamphetamine or theft ring. And then you meet him and you talk to him, and he doesn't have that capacity. I don't think he has that capacity intellectually. I don't think he has that capacity just in terms of criminal competence. It's just not the sort of person he is. Now, we've all dealt with people that are these linchpins, and, you know, quite often they come off as, you know, cunning and even evil, you know, and scary. And he's just none of those things. And it's really hard to square how he is at the center of these cases, to me, right? On paper, it seems pretty obvious, but just to me, it's really hard to square. I know he's accepting responsibility for being here, but just to my mind, it seems a lot more like somebody that got in over his head, that was probably trying to make ends meet and had opportunities presented from other people that he unwisely took advantage of. If you look at his criminal history, it's lengthy in terms of years, but as we discussed today, there was a 13-year gap. Now, that's significant. It shows that he can conform his actions to that which the law requires when he tries, when he needs to, which I guess is always, because the law requires it. But I think it speaks of his ability to do so. Now, during that time, it's my understanding, you know, he owned and ran a party store down in Clare. He took classes at Central Michigan. I mean, there's no cloud during that period. And really, you know, the 10-year gap isn't that commonly applied, because it's hard for recidivist offenders to have that window. So something changed, I guess, when he moves back up. Probably it's the people that he was engaged with. Probably it was his relationships. I think that he met somebody that probably was more engaged in the drug culture than him, that he thought he could help out and assist. And I think it went the wrong way. I think he wasn't strong enough to help that person. And I think that in the process, he got drugged down too. Not an excuse, just an explanation, right? So, I want to say, don't listen to Mr. Ziegler, but I know Mr. Ziegler doesn't come up and ask you for max sentences, right? I think he's got capital insofar as prosecutors in my book, that when he makes that ask, it's something you're going to listen to, because it's not something he asks for every day, right? And it's not like what he was saying was without reason. I mean, it was obviously well reasoned. So what can I ask you to do or to consider to go with the low end of the guidelines? I don't want to, insult anybody's intelligence about the amount of cases that we have here. We could point to aspects of the cases where Mr. Garlaro was forthcoming to law enforcement. When it came to his house, he disclosed the firearms, he volunteered them, he just gave them up, which is why there were no search issues. He basically, anytime other than the first of this series of cases where it was a dropped gun, other than that case, he was forthcoming to questions pretty much immediately. And even in that case, when police officers asked him about where he got the gun, I mean, he fessed up, he told them, he explained everything. So I think his candor to law enforcement, his acknowledgement of his criminal conduct to law enforcement, I think that speaks well of him. I think that while it wouldn't mitigate the offenses to drop it below the guidelines, I certainly think would be a mitigating factor in determining where in the range to situate Mr. Garlaro. I think also the gap in his history is worth acknowledging, although it is already per se acknowledged by the gap, right? So it's already kind of factored in. I think it's worth acknowledging. And then the fact that he has accepted responsibility, that he has, entered a guilty plea and said, yeah, I did these things. I'm putting myself before your honor, rather than, trying to find the technicalities or the loopholes. I think acknowledging that responsibility is worth something in terms of looking towards the lower end of the range. I think realistically, if we look at his age, I guess he's 50. I don't really want to acknowledge that because his birthday is really close to mine. We all know that there's a burnout phase or burnout age in criminal conduct. That people eventually either get it or they don't. If your honor imposed the minimum sentence, he's still going to be committed to the DOC, right? DOC is still going to have him on parole. They're still going to monitor him. And it's a situation where if he goes in for 51 months, which is the bottom, he comes out on parole, he'll be on or probation or however it works. He'll either make it go or he won't. He'll either make it good or he won't. And if he doesn't, all right, if he doesn't learn from those 51 months, if he doesn't reform in 51 months, if he doesn't avail himself of the services that are in MDOC to get whatever problems he has under wraps and under control, then, it will be within the court's power and MDOC's power to put him right back in. And so I don't think your honor has to start off at the high end of the sentence. I think you can start off at the low end with the assumption that that is still a long amount of time, and that should be sufficient to either let him prove himself or not. And if he can't, he's basically proven himself the other way, and he'll be right back in. So I know he hasn't done much here to ask you for the chance, but I'm asking you for the chance. I would ask for a low end sentence just because it's already so high. And he won't be discharged at the end of it anyway. He'll still be under some sort of supervision, and will either have to play by the rules or not. So, thank you.
Thank you. Mr. Garlaro, is there anything you wanted to say today?
Yes, sir. Thank you for the opportunity to give me to make a statement. Unfortunately, yes, I'm not not somebody that my apologies. I'm not a stranger to the law. I'm aware of that. I spent my life locked up somewhere. I've been a foster care since I was 10 years old. In and out of prison, juvenile or jail. I was released in Kentucky in 2002. And from that moment on, my life changed. I went to college full time. I have a bachelor's in sociology because I wanted to become a foster care worker. Me and my partner, we had a party store. I was doing really good. Made a lot of accomplishments. I've been an ordained minister in this county for over 10 years. I've married a lot of couples. I've counseled couples and individuals throughout this time. I've done more help than damage to this community. Tomorrow's my daughter's birthday. This is the first one I'm gonna miss. I've tried really hard. I'm aware that I made choices I should have made and things happen. There's no excuses for it. I'm afraid that I'll be reinstitutionalized. Then I won't be the same again. That's my fear. I'm too old for this. My kids are gonna lose out. I'm not a bad person. The nature of the crime does not necessarily define the nature of one's character. Even though that I judge myself by my intentions, I'm aware now that society judges me by my actions. I'm all clear. Thank you.
Thank you. I did have a chance to review the report, so I'm familiar with all of the circumstances here. In each of these cases, the report laid out very thoroughly the circumstances in your actions. Of course, I'm familiar with you, Mr. Garlaro, through the prior case that we had. And so from that, as well as the additional information in the report, I'm familiar with your circumstances, your background, your history, and so forth. Certainly, your conduct in each of these cases clearly wrongful. you're involved in selling or trading methamphetamine for goods and for weapons, all actions which, can't be mistaken for something that's clearly criminal, clearly wrongful. You were doing all of those things while you were already on probation, which led to a lot of law enforcement's ability to resolve these cases because you're on probation. So you were already kind of under the microscope and already subject to searches and so forth. Yet you continue to put all of that at risk to engage in this conduct. And that's all with regard to the weapons and drugs charges, to say nothing of the assault that you committed on your wife, which was violent based on the description. There's claims in here that I read that you didn't do it, that you're claiming her boyfriend or somebody else was the one. It's pretty hard to mistake who the person is that's assaulting you, and she's pretty clear that you were the one that was doing it. So the assaultive behavior is also concerning to me. The court has the ability, as Mr. Ziegler indicated, to sentence you consecutively because you were on bond and on probation, which would result in significantly longer sentences, for well over 15 years if the court were to sentence you at the high end of the guidelines consecutively. I do think that at the root of all of this is your own substance abuse, and that particularly the assaultive behavior, there were indications from your wife that you were under the influence of methamphetamine or some other type of drug when that occurred. I don't think people's problems with drugs can be stopped by a bond condition. People give up their families, they give up their jobs, their finances, their lives to pursue drugs. The bond condition isn't going to stop that. So the court is not going to sentence you consecutively. However, because of your conduct in this case, because there really could be no mistaking it for being wrongful, because you chose to engage in this conduct while you were on probation and on bond, I do find that sentences at the high end of the guidelines are appropriate to, number one, punish you for your conduct. Number two, hopefully deter you and others from engaging in this type of conduct when you're on bond. As to file number 224645, that's the receiving and concealing charge. The court is going to sentence you to the Michigan Department of Corrections for a period of 23 months to 10 years. On that file, you do have 4 days credit. The court will order restitution in the amount of $850. That's payable to the Kalkaska County Clerk to be dispersed to Nancy Antoine. A crime victim's assessment of $130, court costs of $325, attorney fees of $350, and a $68 state cost. As to file 244885, that's the delivery or manufacture. The court sentences you to 85 months to 20 years in the Michigan Department of Corrections. As to that file, a crime victim's assessment of $130 and a state cost of $68. As to the possession of a firearm by a felon count in that file, 23 months to 5 years in the Michigan Department of Corrections and a $68 state cost. File number 244916, that's the assault charge, 67 months in the Michigan Department of Corrections to a period of 10 years. Crime victim's assessment of $130 and a $68 state cost. Those charges all to run concurrent to each other. As to the probation violation charge, which is
214552 FH.
Thank you, 21455. The court is going to discharge you unsuccessfully from your probation, 120 days jail with credit for 120 days service, and the court will preserve all outstanding fines and costs. You do have the ability to seek and appeal all of these sentences. We're going to provide you with some paperwork that explains to you what your appellate rights are, as well as how to request a court-appointed lawyer to help you with an appeal. Mr. Horowitz, if you could have Mr. Garlaro acknowledge receipt of those.
Yes, signing dated, acknowledging the receipt of the notice of right to appellate review.
All right, Mr. Garlaro, you are remanded to the custody of the state at this time. That concludes our morning docket. Court will be in recess until